This is the sixth video in revision series on Indian polity. We have already uploaded 5 videos on Indian polity, and the aim is to finish this series well before prelims examination and to make it a one-stop solution for revision of Indian polity. You can find the link to the playlist down below in the description box and also as a pinned comment. So outline of this video is like this. First, we will take overview of Article 5 to 11 and Citizenship Act. Overview is mostly in Hindi, but screen content will be in English. After I finish overview, the bulk of explanation will be in English. So for that, I have provided timestamp. You can take a look at that. Second, we will understand Article 5 to 11 in detail. Third, we will discuss Citizenship Act of 1955. Fourth, we will discuss the recent controversial 2019 amendment to Citizenship Act of 1955. Finally, we will learn the difference between OCI, PIO, NRI, etc. in short. So in the next 20 minutes, we will revise the citizenship chapter in such a way that you won't need to go to any other video to understand citizenship latter. So grab your pen and paper, take running notes if you want, or download these notes from PDF membership handle. If you don't want to take notes, take screenshot from the screen. You can also keep Lakshmikant handy and highlight or make notes in margin. Rewatch the part if it is too difficult to understand. On contrary, if you find it too slow, you can always increase the speed to 1.25x. So hang tight for next 20 minutes and we will finish the citizenship chapter in 20 minutes only.
दोस्तों सिटीजनशिप बोले तो मेंबरशिप ऑफ अ पॉलिटिकल कम्युनिटी बिकॉज ऑफ विच यू एंजॉय सर्टन राइट्स लाइक राइट टू वोट, राइट टू कॉन्टेस्ट इलेक्शन. इन इंडिया सिटीजन एंजॉय सर्टन फंडामेंटल राइट्स लाइक राइट टू इक्वालिटी, राइट टू फ्रीडम अंडर आर्टिकल 15, 16, 19, 29, 30. ऑल्सो सिटीजन्स आर मोरली ओब्लाइज्ड टू परफॉर्म सम ड्यूटीज जैसे कि टैक्स पे करना, हिस्टोरिकल प्लेसेस का जतन करना. वैसे इंडिया में सिटीजनशिप के रूल्स दो जगह मेंशन होते हैं. First, Article 5 to 11 of the Indian Constitution, and second, under Citizenship Act of 1955. First one says, who will be citizen of India at the time of commencement of the Constitution? यानी कि 26 जनवरी 1950 के टाइम इंडिया का सिटीजन कौन, यह आर्टिकल 5 to 11 में लिखा है. बट 1950 के बाद इंडिया का सिटीजन कौन बनेगा, इट इज डिसाइडेड एज पर सिटीजनशिप एक्ट 1955. और ऐसे एक्ट बनाता कौन है? द पार्लियामेंट. लास्ट वीडियो में हमने देखा कि सिटीजनशिप के रूल्स दो जगह पे मेंशन होते हैं, आर्टिकल 5 से 11 एंड सिटीजनशिप एक्ट 1955. आर्टिकल 5 से 9 ये बताता है 26 जनवरी 1950 को यानी कि एट द कमेंसमेंट ऑफ द कॉन्स्टिट्यूशन कौन इंडिया का सिटीजन बनने के लायक है एंड कौन नहीं. अगर कोई इंडिया का परमानेंट रेजिडेंट यानी कि डोमिसाइल है या फिर जिसका बर्थ या फिर जिसके पेरेंट्स का बर्थ अगर इंडियन टेरिटरी पे हुआ है देन ही विल बी सिटीजन ऑफ इंडिया, ऐसा आर्टिकल 5 कहता है. अगर कोई पाकिस्तान से इंडिया माइग्रेट हुआ है देन उसका सिटीजनशिप का राइट एंड कंडीशंस आर्टिकल 6 में मेंशन किया है. अगर कोई इतना कंफ्यूज था कि आफ्टर इंडिपेंडेंस वो पहले इंडिया से पाकिस्तान माइग्रेट हुआ देन ही रिटर्न टू इंडिया, अगर ऐसा कोई है तो उसके सिटीजनशिप के राइट्स एंड कंडीशंस आर्टिकल 7 में प्रोवाइड किए गए हैं. आर्टिकल 8 प्रोवाइड्स फॉर राइट्स एंड कंडीशंस ऑफ सिटीजनशिप ऑफ अ पर्सन हुज ग्रैंड पेरेंट्स वर बोर्न इन इंडिया, देन बाय रजिस्ट्रेशन थ्रू डिप्लोमेटिक एंड कॉन्सुलर मींस ही कैन बिकम सिटीजन ऑफ इंडिया. आर्टिकल 9 कहता है द मोमेंट यू अक्वायर फॉरेन सिटीजनशिप, आपकी इंडियन सिटीजनशिप तो गई. सिटीजनशिप के रिगार्डिंग असली मजे तो पार्लियामेंट ले रही है. वो कैसे, ये जानेंगे हम इस वीडियो में. आर्टिकल 10 कहता है कि अगर आप आर्टिकल 5 से लेकर 9 तक कोई भी राइट और कंडीशंस के तहत अगर इंडियन सिटीजन बन गए तो यू विल कंटिन्यू टू बी सिटीजन ऑफ इंडिया एंड आपकी सिटीजनशिप को कोई हाथ भी नहीं लगा सकता अनलेस कल जाके पार्लियामेंट कोई नया लॉ बना ले. सो आर्टिकल 10 टॉक्स अबाउट कंटिन्यूएशन ऑफ राइट ऑफ सिटीजनशिप सब्जेक्टेड टू पार्लियामेंट. एंड अबाउट ऑल दिस इंडियन कॉन्स्टिट्यूशन का आर्टिकल 11 पार्लियामेंट को अल्टीमेट पावर देता है टू डिसाइड कौन इंडिया का सिटीजन बनेगा या फिर कौन इंडियन सिटीजनशिप से हटाया जाएगा. तो सिटीजनशिप के रिगार्डिंग असली माए बाप तो पार्लियामेंट है बिकॉज ऑफ आर्टिकल 11. अंडर आर्टिकल 11 कॉन्स्टिट्यूशन ने सिटीजनशिप के रिगार्डिंग लॉ बनाने की पावर पार्लियामेंट को दी है. ये पावर का यूज करके पार्लियामेंट ने सिटीजनशिप एक्ट ऑफ 1955 पास किया. उसको हम डिटेल में देखेंगे इन नेक्स्ट वीडियो. कॉन्स्टिट्यूशन ये तो बताता है कि ऑन 26 जनवरी 1950 को इंडिया का सिटीजन कौन बनेगा. बट अगर 1950 के बाद किसी को इंडिया का सिटीजन बनना है तो क्या,
उसके रिगार्डिंग कॉन्स्टिट्यूशन एकदम चुप है. सो फॉर दैट आर्टिकल 11 के अंडर अपनी पावर को इस्तेमाल करके पार्लियामेंट ने सिटीजनशिप एक्ट ऑफ 1955 पास किया, विच डील्स विद द प्रॉब्लम्स ऑफ लॉस और एक्विजिशन ऑफ सिटीजनशिप. ये लॉ 9 बार अमेंड भी किया गया है इन ईयर्स शोन. रिसेंट वाली अमेंडमेंट इज 2019 Citizenship Amendment Act. Citizenship Act provides for grounds for acquisition of citizenship. You can remember those grounds by using mnemonic brand. B for birth, R for registration, A for acquisition of territory, N for naturalization, and D for descent. Similarly, grounds of loss of citizenship are R, T, D. R for renunciation, T for termination, D for deprivation. Article 5 to 11 of the Indian Constitution. The population of the state is divided into two classes, that is, citizens and aliens. Citizens are people who enjoy full civil and political rights, such as the right to vote, the right to contest elections, eligibility to hold certain offices. Only citizens enjoy Article 15, 16, 19, 29 and 30 of the Indian Constitution, which are certain fundamental rights. Another set of people is aliens. They are citizens of some other nation state. Aliens are further divided into friendly aliens and enemy aliens. Friendly aliens belong to a country that has cordial relations with India. On the other hand, enemy aliens belong to a nation at war with India. And they do not enjoy protection against arrest and detention, which is Article 22 of the Indian Constitution. Now, rules of citizenship are written in two places. First, Part 2 of the Constitution of India, that is Article 5 to 11. And second, Citizenship Act of 1955. Article 5 to 11 is a declaration of citizenship on the 26th January 1950. Simply, it deals with persons who became citizens on the day of the commencement of the Constitution. This part does not say how to acquire Indian citizenship in future. Secondly, Citizenship Act of 1955. It deals with acquisition and termination of citizenship since it was not mentioned in the original constitution. How to acquire citizenship of India if one desire. So, the constitution empowered Parliament to enact a law to provide for such matters and any other matter related to citizenship. In this lesson, we shall deal with the first, that is Part 2 of the Indian Constitution, Article 5 to 11. Here, Article 5 to 8 deals with who became a citizen of India on 26 January 1950. So as per Article 5, every person domiciled in India becomes a citizen of India. A person who was born in India or either of the parents was born in India or a resident of India for 5 years immediately before the date of commencement of the Constitution, which was 26 January 1950. If any of A, B or C satisfied, he or she became a citizen of India. Now, here it is necessary to differentiate domicile and resident. Generally, a domicile is a place of your ancestors, your permanent home, a place where you belong. A residence, on the other hand, is a place where you live for the time being. It is your temporary home. For example, you must be residing in Delhi for your preparation. One must be living in Bengaluru for a temporary job. So this was about Article 5. Now let us move to Article 6. Person migrated to India from Pakistan before 19 July 1948 became a citizen of India on Republic Day. Many Sikh and Muslim brothers who migrated to India became a citizen of India with the help of this provision under Article 6. Now what about a person migrating after 19 July 1948? Suppose a person was migrating to India after 19 July 1948. He was registered after he resided in independent India for 6 months and then he became citizen of India. Now let us talk about Article 7. A person is migrated to Pakistan from India after 1st March 1947. A person is migrating to Pakistan. Then he figured out a better place to live and returned for resettlement to India. He shall become a citizen of India after residing in India for 6 months and registration under Article 7. Now let us move to Article 8. Article 8 deals with the rights of citizenship of a person of Indian origin residing outside India. A person born in India or any of the parents or any of the grandparent born in undivided India residing outside India became a citizen with the help of a diplomatic channel. So this was Article 8. So in short, Article 5, 6, 7 and 8 talked about persons who became citizens on the 26th January 1950. Now moving to the next article. According to Article 9, if a person voluntarily acquires foreign citizenship, that person will no longer be a citizen of India. That means India doesn't allow for dual citizenship. Next, Article 10 says that your right to citizenship is subjected to the provisions of any law made by the Parliament. That means your citizenship is subjugated to the Parliament. And finally, Article 11. It empowers the Parliament to make any provisions regarding acquisition and termination of citizenship and all the other matters related to citizenship. The Parliament exercised this power conferred by Article 11 and made the Citizenship Act of 1955, which deals with acquisition and termination of Indian citizenship. Part 2 of the Indian Constitution provided who are eligible to be a citizen of India on Republic Day, that is, at the commencement of the Constitution. On the other hand, Citizenship Act 1955 provides for the acquisition of Indian citizenship after the commencement of the Constitution. As per the Indian Citizenship Act 1955, a person born in India or has Indian parentage or has resided in India over a specified time is eligible for Indian citizenship. Without the Citizenship Act 1955, Part 2 of the Indian Constitution has very little meaning. The Citizenship Act of 1955 provided 5 ways of attaining Indian citizenship, that is, by birth, by descent, by registration, by naturalization, and by incorporation of territories. Let us dig deeper and take a look at it one by one. By birth. Every person born in India on or after January 26, 1950, but before July 1, 1987, is an Indian citizen irrespective of the nationality of his or her parents. Also, every person born in India between July 1, 1987 and December 2, 2004 is a citizen of India given either of his or her parent is a citizen of the country at the time of his or her birth. Finally, a person born in India on or after December 3, 2004 is a citizen of the country given that both parents are Indians or at least one parent is a citizen and the other is not, an illegal migrant at the time of birth. Now, what are the illegal migrants? An illegal migrant is a foreigner who enters the country without valid travel document like a passport and visa, or enters with valid documents but stays beyond the permitted period. In short, person born in newly independent India becomes Indian citizen under the Citizenship Act of 1955 provided that he fulfills some of the criteria. Let us move to the second way of attaining Indian citizenship, that is by descent. A person born outside India on or after January 26, 1950 is a citizen of India by descent if his or her father was a citizen of India by birth. Suppose a person born outside India on or after December 10, 1992 but before December 3, 2004 has to acquire Indian citizenship. He can become Indian citizen by descent if either of his or her parents was a citizen of India by birth. Suppose a person outside India after December 3, 2004 has to acquire Indian citizenship. In that case, his or her parents have to declare that the minor does not hold the passport of another country and his or her birth is registered at an Indian consulate within 1 year of birth. So, in short, person born outside India but his parents or either of his parents is an Indian citizen, he can become Indian citizen by descent. Now, the third way of attaining Indian citizenship is by registration. A migrant can acquire Indian citizenship by registration. And some of the mandatory rules to follow here are: first, a person of Indian origin who has been a resident of India for 7 years before applying for registration can acquire Indian citizenship. Second, a person of Indian origin who is resident of any country outside undivided India can become Indian citizen. 3. A person who is married to an Indian citizen is ordinarily resident for 7 years before applying for registration. Also, fourth, minor children of Indian citizens can acquire Indian citizenship by registration. Fifth, any person who himself or either of his parents was Indian citizens earlier and again want to become a citizen shall come and stay for minimum of 1 year to become Indian citizen under the Citizenship Act by registration. Finally, an overseas citizen of India for 5 years shall come and reside for a minimum of 1 year before applying for Indian citizenship by registration. So these were the criteria to acquire Indian citizenship by registration. Under registration, Indian origin staying abroad can register as an Indian citizen, and those married to an Indian citizen after some years of residence can get Indian citizenship. Now, the fourth way of attaining Indian citizenship is by naturalization. A person can acquire citizenship by naturalization if he or she is ordinarily a resident of India for 12 years, throughout 1 year preceding the date of application and 11 years in the total, and fulfills all qualification in the third schedule Citizenship Act, which mainly deal with the oath of allegiance, adherence to duties and good moral characters. Finally, by incorporation of territory, a person can become an Indian citizen. If a new territory becomes part of India, the government of India shall notify the person of that territory as citizen of India. So these were the 5 ways of attaining Indian citizenship under the Citizenship Act of 1955. The Citizenship Act 1955 also lays down the 3 modes by which an Indian citizen, whether a citizen at the commencement of the Constitution or subsequent to it, may lose his citizenship. The 3 modes of loss of Indian citizenship are renunciation, termination, and deprivation. Renunciation: if a person voluntarily gives up its citizenship, he will be no longer citizen of India. Second, termination: acquiring citizenship of another country automatically results in loss of Indian citizenship. Finally, deprivation: if a citizenship is acquired by fraud, false representation, concealment of material fact, obtained by registration or naturalization, or being disloyal to Constitution, is another way of losing Indian citizenship under the Citizenship Act of 1955. So these were the 3 modes of loss of Indian citizenship under the Citizenship Act of 1955. Now, one point you should know is that the power to grant citizenship lies only with the Home Ministry. And India is one of the few countries whose citizenship law is incorporated in the Constitution itself. That is Part 2, Article 5 to 11 of the Indian Constitution. Let us understand the Citizenship Amendment Act of 2019 in short. It grants certain benefits to individuals from Afghanistan, Bangladesh and Pakistan who entered India on or before December 31, 2014. But this benefit is limited to individuals who identified as Hindu, Sikh, Buddhist, Jain, Parsi or Christian. So these people will not be considered illegal migrants and will be eligible to acquire Indian citizenship with relaxed norms. These individuals will be able to apply for citizenship after residing in India for 6 years only, as opposed to the standard 12 years, even if they do not possess the necessary documentation. The Act also reduces the residency requirement for individuals belonging to these religions and originating from these three countries from 11 years to 5 years. Now let us understand the final part, that is difference between NRI, PIO and OCI. See, NRI is an Indian citizen. He is Indian citizen living outside of India and who holds an Indian passport. He is temporarily residing outside India, maybe for job or any other activity. PIO is an individual who or whose ancestors were Indian nationals and currently holds citizenship, nationality from another country. A person of Indian origin means a foreign citizen, but except national of Pakistan, Afghanistan, Bangladesh, China, Iran, Bhutan, Sri Lanka, and Nepal. They need visa to visit India. See, PIO, that is person of Indian origin, needs visa to visit India. If the period of stay is for more than 180 days, then they also are required to register with local police authorities. Now this was about PIO. Now next is OCI, that is Overseas Citizen of India. It is an individual who is registered as Overseas Citizen of India card holder under section 7A of the Citizenship Act 1955. OCI can visit India without visa for lifelong. The OCI category was introduced by the government in 2005 only. This category was introduced in 2005. Only after 5 years, OCI card holder can even apply for citizenship of India. Now there are few limitations on them that distinguish themselves from full-time Indian citizens, that they do not get voting rights as of now, and they also cannot hold a government job and purchase agriculture or farmland in India. Now remember this, in 2015 PIO was merged with OCI. So in this video we revised the chapter of Citizenship of India. We learned Article 5 to 11. Then we learned about Citizenship Amendment Act, Citizenship Act of 1955 and Amendment of 2019. After that we learned the difference between NRI, PIO and OCI category. So I hope these revision videos are helping you in your preparation. So in the next video, we will discuss the important chapter, that is fundamental rights. So be there. Link to the playlist is given down below in the description and in comment section as a pinned comment. So if you have any doubt regarding polity, you can comment down below in comment section. I will try to resolve your query there and there only. So thank you for your time. Have a good day. All the best.